John Jay, the first Chief Justice of the United States. He was a member of the First and Second Continental Congresses and the fifth President of the Continental Congress. He was one of the authors of the Federalist Papers, writing 5 of them. He was appointed Chief Justice of the United States by President George Washington in 1789. He and the other justices ruled in Chisholm v. Georgia that states did not enjoy sovereign immunity and that state governments must obey the federal government. In 1794, he traveled to England as a special envoy and concluded the so-called Jay Treaty, which eased tensions between the two countries and averted a possible war. He withdrew from the Supreme Court after being elected governor of New York. President John Adams renominated him for Chief Justice, but he declined, citing ill health and the lack of energy, importance, and majesty of the court, which it requires to support the government of the country. The second Chief Justice of the United States, John Rutledge. On June 28, 1795, Chief Justice John Jay resigned because he had been elected governor of New York. Washington appointed him to replace Jay as Chief Justice. On July 16th, he delivered a highly controversial speech denouncing the Jay Treaty with Great Britain. In the speech, he reportedly said he would prefer war to this treaty. On December 10th, Rutledge was officially nominated as a Supreme Court Justice. On December 15th, the Senate rejected his appointment by a vote of 14 to 10. This was the first time the Senate had rejected a Supreme Court nomination. It was also the only Supreme Court recess appointment not confirmed to date. He suffered a nervous breakdown as a result. On December 26, he attempted suicide by jumping from a pier into Charleston Harbor and was rescued by 2 slaves. He resigned on December 28, the shortest tenure, 138 days, of any Chief Justice of the United States. The third Chief Justice of the United States, Oliver Ellsworth. He was the principal author of the Judiciary Act of 1789. The act shaped the U.S. federal judicial system by establishing the Supreme Court's constitutional interpretation power to overturn state Supreme Court decisions that were contrary to the U.S. Constitution. On March 3, 1796, he was nominated by President George Washington to be Chief Justice of the Supreme Court, and the nomination was unanimously approved by the U.S. Senate the next day. During his tenure, he changed the practice of each justice writing separate opinions in the same case and delivering them from the bench. He encouraged the justices to agree by consensus before expressing themselves in a single written opinion, a practice that continues to this day. From 1799 to 1800, he was also the French envoy who signed the Convention of 1800 to end the state of quasi-warlike relations between the United States and France. He resigned on December 15, 1800, due to ill health. The fourth U.S. Chief Justice, John Marshall. He was nominated by President Adams to succeed incumbent Chief Justice Oliver Ellsworth, who had resigned because of ill health. His tenure as Chief Justice spanned 6 presidents. Through the Marbury v. Madison decision, he declared that the validity of laws enacted by Congress must be determined by the Supreme Court, which has the power to interpret the Constitution. This established the practice that the Supreme Court had the power to declare laws enacted by Congress invalid and unconstitutional. With this decision, he contributed to the formation of the American constitutional landscape, in which the Supreme Court became truly independent and equal to the other branches of the federal government. With the treason trial of Vice President Burr, he established strict evidentiary requirements for the constitutional offense of treason, effectively preventing it from becoming a tool for political persecution. President John Adams said of him, "My gift of John Marshall to the people of the United States was the proudest act of my life." The fifth Chief Justice of the United States, Roger B. Taney. Upon nomination by President Jackson, he succeeded Chief Justice John Marshall, who had died of illness. He was a devout Roman Catholic who had gratuitously emancipated the black slaves he inherited. He believed in the paramount importance of rights and liberties and opposed attempts by political power to regulate or control restrictions on individual rights, especially the right of individuals to own slaves. In his view, the framers of the Constitution believed that the Negro could be legally reduced to slavery to serve the interests of his master. In Scott v. Sanford, he ruled that people of African descent were not citizens of the United States, even if they were free blacks, for the purposes of the U.S. Constitution. The Scott v. Sanford decision caused an uproar in the United States at the time, and caused the people of the time to rethink the issue of the existence of black slavery, and is considered to have been a major impetus for the Civil War. The sixth U.S. Chief Justice, Salmon Portland Chase, nominated by President Abraham Lincoln, he succeeded Chief Justice Taney, who died of an illness. One of his first acts was to make John Rock the first African-American lawyer to hear a case before the Supreme Court. In Texas v. White, he ruled that the federal Constitution established a permanent union between the states, not a contract that Texas had made with other states, that Texas had never been outside the Union, and that any claim of secession or enforcement of the Ordinance of Secession on the part of Texas was therefore invalid. He presided over the Senate impeachment trial of President Andrew Johnson in 1868. The U.S. federal currency, the U.S. dollar, was printed when he was Secretary of the Treasury in 1861-1862, and in 1864 he wrote the words, "In God We Trust," on U.S. coins. His portrait appears on the U.S. $10,000 bill, which is the largest denomination of the U.S. dollar in public circulation. The seventh U.S. Chief Justice, Morrison Remick Waite, nominated by President Grant, he succeeded Chief Justice Chase, who died of an illness. In the regulation of economic activity, he supported broad state authority, arguing that the federal commerce power must keep pace with the progress of the country. In United States v. Cruikshank, he ruled that the states must be relied upon to protect citizens from attack by other private citizens. Sovereignty belongs to the states alone. The federal government has no duty or power to punish false imprisonment or murder conspiracies within a state's borders. In Minor v. Happersett, he supported the right of states to deny women the franchise. Nonetheless, he sympathized with the feminist movement and supported the admission of women to the Supreme Court bar. His opinion in Munn v. Illinois wrote that businesses or private property should be subject to governmental regulation when they were affected with a public interest. As Chief Justice, he swore in Presidents Hayes, Garfield, Arthur, and Cleveland. The eighth Chief Justice of the United States, Melville Fuller, nominated by President Cleveland, he succeeded Chief Justice Waite, who had died of illness. He introduced the practice of the justices shaking hands before private conferences and maintained more or less cordial relations among the justices. But they were still split 5.4 on 64 times during his tenure. He was the first Chief Justice to lobby Congress directly in favor of legislation, and he successfully urged Congress to pass the Circuit Courts of Appeals Act of 1891. In Chicago, Milwaukee M. St. Paul Railroad, Comber v. Minnesota, he and 5 other justices voted to strike down railroad rates set by the Minnesota Commission, intending to diminish the state's power to regulate economic activity. In the case of In re Debs, Fuller and his fellow justices bolstered the judiciary's authority to enjoin deprivations of public rights. In the case of Williams v. Mississippi, he supported the disenfranchisement of African Americans in Mississippi. In 1893, he rejected President Cleveland's offer of the appointment of Secretary of State. The ninth Chief Justice of the United States, Edward Douglas White. In 1894, President Grover Cleveland appointed White as an Associate Justice of the U.S. Supreme Court. In 1910, President William Howard Taft elevated him to the position of Chief Justice following the death of Melville Fuller. He was the first incumbent Associate Justice to be appointed as Chief Justice. In 1896, he sided with the 6 justices who favored segregation in the majority opinion in Plessy v. Ferguson. He originated the term rule of reason and was generally seen as one of the more conservative members of the court. He wrote the 1916 decision upholding the constitutionality of the Adamson Act, which mandated a maximum 8-hour workday for railroad employees. In the selective draft law cases, he upheld the Selective Service Act of 1917 and, more generally, upheld conscription in the United States, which President Taft said was one of his great opinions. The 10th Chief Justice of the United States, William Howard Taft. He is the only person in history to have held both the offices of President of the United States and Chief Justice of the United States, having been elected the 27th President from 1909 to 1913 and the 10th Chief Justice from 1921 to 1930. In Stafford v. Wallace, he ruled for a 7-1 majority that the processing of animals in stockyards was so closely tied to interstate commerce as to bring it within the ambit of Congress's power to regulate. In Myers v. Oz, United States, he noted a decision holding that Congress lacked the power to require the President to obtain Senate approval before removing an appointee because the Constitution does not limit the President's power to remove an official from office. In United States v. Lanza, he noted that the state and federal governments were dual sovereigns, each empowered to prosecute the conduct in question. He argued that the Chief Justice should have an administrative staff to assist him, and the Chief Justice should be empowered to temporarily reassign judges. The 11th U.S. Chief Justice, Charles Evans Hughes, President Hoover appointed him to replace Chief Justice Taft, who had resigned due to illness. In Neer versus Minnesota, he held in the majority opinion that the First Amendment barred states from violating freedom of the press. He wrote the majority opinion in Stromberg versus California, which represented the first time the Supreme Court struck down a state law on the basis of the incorporation of the Bill of Rights. Writing the majority opinion in ALA Schechter Poultry Corp. v. United States, he held that Roosevelt's National Industrial Recovery Act of 1933 was doubly unconstitutional, falling afoul of both the Commerce Clause and the non-delegation doctrine. He wrote a concurring opinion in Carter, in which he agreed with the majority's holding that Congress could not use its Commerce Clause powers to regulate activities and relations within the states, which affect interstate commerce only indirectly. He upheld the constitutionality of the Wagner Act, which marked a turning point for the Supreme Court, as the court began a pattern of upholding New Deal laws. The 12th U.S. Chief Justice, Harlan Fiske Stone. In 1941, President Franklin D. Roosevelt nominated him to replace the retiring Hughes as Chief Justice. He was the first Chief Justice not to have served in elected office. As Chief Justice, he spoke for the court in upholding the president's power to try Nazi saboteurs captured on American soil by military tribunals in ex parte Quirin. He also wrote one of the major opinions in establishing the standard for state courts to have personal jurisdiction over litigants in International Schuko v. Washington. As Chief Justice, he described the Nuremberg Court as a fraud on Germans, even though his colleague and successor as Associate Justice, Robert H. Jackson, served as the Chief U.S. Prosecutor. He was the fourth Chief Justice to have previously served as an Associate Justice, and the second to have served in both positions consecutively. To date, he is the only justice to have occupied all 9 seniority positions on the bench, having moved from most junior Associate Justice to most senior Associate Justice, and then to Chief Justice. The 13th U.S. Chief Justice, Frederick Moore Vinson. He was nominated by President Harry S. Truman on June 6, 1946, to become Chief Justice of the United States, following the death of Harlan F. Stone. In his time on the Supreme Court, he wrote 77 opinions for the court and 13 dissents. His most dramatic dissent was when the court voided President Truman's seizure of the steel industry during a strike in a June 3, 1952, decision, Youngstown Sheet Tube Coda vs. Sawyer. On racial segregation, he wrote that states practicing the separate but equal doctrine must provide facilities that were truly equal, in Sweat vs. Painter and McLaurin vs. Oklahoma State Regents. His final public appearance at the court was when he read the decision not to review the conviction and death sentence of Julius and Ethel Rosenberg. After Justice William O. Douglas granted a stay of execution to the Rosenbergs at the last moment, he sent special flights out to bring vacationing justices back to Washington in order to ensure the execution of the Rosenbergs. The 14th U.S. Chief Justice, Earl Warren I. In October 1953, he accepted Eisenhower's recess appointment as the Chief Justice of the United States. He presided over the case of Brown versus Board of Education, after the Supreme Court formally voted to hold that the segregation of public schools was unconstitutional. He drafted an 8-page outline from which his law clerks drafted an opinion. In the 1956 term, the Warren Court received condemnation from right-wingers such as U.S. Senator Joseph McCarthy by handing down a series of decisions, including Yates versus United States, which struck down laws designed to suppress communists and later led to the decline of McCarthyism. He saw the Bill of Rights as a codification of the natural rights of man against the government and believed that incorporation would bring the law into harmony with moral principles. In Elkins versus United States, he joined with the majority in striking down the Silver Platter Doctrine, a loophole to the exclusionary rule that had allowed federal officials to use evidence that had been illegally gathered by state officials. The 14th U.S. Chief Justice, Earl Warren II. In the landmark case of Miranda versus Arizona, Warren wrote the majority opinion, which established a right to counsel for every criminal suspect and required police to give criminal suspects what became known as a Miranda warning, in which suspects are notified of their right to an attorney and their right to silence. In Reynolds versus Sims, he indicated that the Equal Protection Clause required that state legislative districts be apportioned on an equal basis, upholding the principle of one man, one vote. In Peterson versus Greenville, he wrote the court's majority opinion, which struck down local ordinances that prohibited restaurants from serving black and white individuals in the same room. In 1967, he wrote the majority opinion in the landmark case of Loving versus Virginia, in which the court struck down state laws banning interracial marriage. Shortly after the assassination of John F. Kennedy, he served as Chief Justice of the United States and Chairman of the Warren Commission, and the commission unanimously concluded that the assassination was the result of a single individual, Lee Harvey Oswald, who acted alone. The 15th U.S. Chief Justice, Warren Earl Burger. In 1969, President Richard Nixon nominated him to succeed Earl Warren as Chief Justice. In the most controversial ruling of his term, Roe v. Wade, he voted with the majority to recognize a broad right to privacy that prohibited states from banning abortions. He wrote the majority opinion for Milliken v. Bradley, which upheld de facto school segregation across school district lines if segregationist policy was not explicitly stated by all of the districts involved. In 1974, he wrote for a unanimous court in United States v. Nixon, which rejected Nixon's invocation of executive privilege in the wake of the Watergate scandal. The ruling played a major role in Nixon's resignation. In Immigration and Naturalization Service v. Chadha, he held for the majority that Congress could not reserve a legislative veto over executive branch actions. He began a tradition of annually delivering a State of the Judiciary speech to the American Bar Association. The 16th U.S. Chief Justice William Rehnquist. When Burger retired in 1986, President Ronald Reagan nominated him for Chief Justice. He tightened up the justices' conferences, keeping justices from going too long or off track, and not allowing any justice to speak twice until each had spoken once. He successfully lobbied Congress in 1988 to give the court control of its own docket, cutting back on mandatory appeals and certiorari grants in general. He voted with the majority in City of Bourne v. Flores and referred to that decision as precedent for requiring Congress to defer to the court when interpreting the 14th Amendment, including the Equal Protection Clause, in a number of cases. He authored the majority opinion in South Dakota v. Dole, upholding Congress's reduction of funds to states not complying with the national 21-year-old drinking age. In both Kimmel v. Florida Board of Regents and Board of Trustees of the University of Alabama v. Garrett, the court held that Congress had exceeded its power to enforce the Equal Protection Clause. In both cases, he was in the majority that held discrimination by states based upon age or disability, as opposed to race or gender, need satisfy only rational basis review as opposed to strict scrutiny. He wrote for a 5-4 majority in United States v. Lopez, striking down a federal law as exceeding congressional power under the clause. In 1992, he joined a dissenting opinion in Lee v. Wiseman, arguing that the Free Exercise Clause of the First Amendment only forbids government from preferring one particular religion over another. He also led the way in allowing greater state assistance to religious schools, writing another 5-4 majority opinion in Zellman v. Simmons-Harris that approved a school voucher program that aided church schools along with other private schools. In Van Orden v. Perry, he wrote the plurality opinion upholding the constitutionality of a display of the Ten Commandments at the Texas State Capitol in Austin. He wrote a concurrence agreeing to strike down the male-only admissions policy of the Virginia Military Institute as violating the Equal Protection Clause, but declined to join the majority opinion's basis for using the 14th Amendment. In 2000, he wrote a concurring opinion in Bush v. Gore, the case that ended the presidential election controversy in Florida, agreeing with 4 other justices that the Equal Protection Clause barred the standardless manual recount ordered by the Florida Supreme Court. He believed that federal judges should not impose their personal views on the law or stray beyond the framers' intent by reading broad meaning into the Constitution. He saw himself as an apostle of judicial restraint. Because of his votes in gay rights cases, ICT UP regarded him as a leading figure in the anti-gay movement in America. According to Professor Erwin Chemerinsky, he presided over a Federalist Revolution as Chief Justice.